Okay, how's everyone doing? Everyone hear me? Yeah? Okay. We start? Guys, start? You can't hear me? So I'm actually sitting down, unfortunately, because actually I feel fine, but today's the Jewish holiday of Yom Kippur, where I'm supposed to be fasting. I'm not eating, so I'm trying to conserve and guard my strength. I can't eat till 8 o'clock tonight. Oh, you guys are awesome.
It was free and I didn't take it. So.
Don't make me say it. This is the oh, never mind, the dilemma, I suppose. Yeah. Anyway, so I will use the mic and I will sit down to gird my strength. I have 2 back-to-back classes and I can eat later tonight. Okay, so I don't like sitting though. I prefer standing, but I'll do it for today. All right, so any questions on the title searching, on the records, on the race notice statutes? Any questions on that stuff? Anything in your minds? Okay, so today is a one-off topic. It doesn't really fit anywhere. And indeed, I think you studied this in torts, didn't you?
Yeah.
Right, yeah. I figured that you did at some point. And I'm guessing you already did a couple of these cases too, like Del Webb? Okay, and I know you've done it. So my goal for today is to teach it to you from a different perspective, if I may. Okay. You guys hearing feedback? Yeah, I can't do anything about it. All right. So the topic of nuisance, again, is really a topic for torts, right? It's a topic you study when one person bothers another. But it's inherently a property problem as well, because these issues often arise in real estate deals, real estate transactions. So what I want to cover today is how the courts handle nuisance. And I'm not so much interested in you having memorized what are the elements of a nuisance, what's the difference between a public and a private nuisance, and you know, whether it's noise or vibration. That you say that already, that's torts, right? What I'm interested in discussing today is the remedy for a nuisance. And there are always 2 possible remedies for a nuisance, one of which is an injunction, and one of which is damages. And the decision of the court to choose damages or an injunction is the most significant decision. So before I begin, I just want to point out an illustration which I know you're all familiar with because you live here in Houston and have discussed before, which is the Ashby high-rise. Everybody know about this? So the Ashby high-rise was meant to be this, you know, high-scale condominiums in Rice Village. It's on Ashby and Bissonnette, which is not too far from here. And years ago, I think we're at year 6 or 7 at this point, developers announced they wanted to build this high-rise complex in the middle of Rice Village, and it's in a residential area, all one-family homes. The neighbors came out in full force against it. They had protests. They put these horrible yellow signs throughout, these scary signs. They can stop the Ashby high-rise, right? Throughout the entire Rice Village area. You can still see them there today. Fast forward many years, and finally they got to breaking ground. And shortly after they broke ground, a lawsuit was filed. Okay, what does this lawsuit say? The lawsuit said that the Ashby high-rise was a nuisance. How's it a nuisance? Not because it blocks sunlight or it causes pollution or even because it causes traffic. They said it was a nuisance because the building was, quote, out of place. What do you mean out of place? Well, they said it's a nuisance because it doesn't belong here. And we can discuss this a little bit later more in details. But what's very interesting is what happened afterwards, right? What did the court do? Okay. Did the court say, yep, it's a nuisance, you can't build? No, what the court actually says, yes, it's a nuisance, but we'll pay damages instead of having an injunction, right? Instead of issuing an injunction to hold up the building, they just said, oh yeah, we'll award damages based on how much your property values are diminished. If you think about it for a second, this is very significant because traditionally the remedy for a nuisance is an injunction. Move the feedlot in Del Webb, right? In the first case, the North Carolina case, stop having the the oil refinery. But the second case, the Boomer case, the cement case, said, okay, you know what? It's going to be a very big deal if we shut down this factory. So let's just, have them pay damages and move on. And so the Ashby case, which happened, it's on appeal right now in your courts right here in Houston, recognized this important distinction between injunction and damages. And all of us law professors in town are still arguing over this, whether this was proper or not. I think it probably wasn't. But this is what I want you to gather, and this is indeed very practical, because any of you have any sort of real estate disputes, eventually one side wants damages, the person being bothered. I'm sorry, one side wants damages, that's the person who is actually making the problem. And the other side wants the injunction. This is a side who, doesn't want to be bothered. And usually there's a huge difference in cost. In the air conditioner case, right? The cost of paying damages and actually stop making noise from the air conditioner, right? So any questions before we get started? No? Okay. So I'm going to try to talk less than usual today, which means more from you guys. Shouldn't be too bad. Okay, where did I finish last time?
I was the last time we
Okay, thanks, Alex. So is that Chris's next or you're next? Oh, Ryan, you weren't here, so you gotta go in. All right, so Ryan, let's start with Morgan, the North Carolina case. Just give us the facts, please, here.
Yes, sir. So the plaintiffs in the case have a piece of land, and on that land they have a house, a restaurant, and it's like a trailer rental area as well.
Trailer park, as it's commonly known, yes.
And the defendant owned and operated an oil refinery, which is about 1,000 feet away from the residence. And the plaintiffs are basically complaining because all hours of the day and night they're filling trucks and running this refinery. Noise, gas, odor, the works.
Okay, good. So Ryan, is there any doubt that this this oil refinery is causing some sort of a nuisance in terms of smell and gas and pollution? Is there any doubt about that?
No.
Okay. So the question becomes, what is the court going to do about it? And this is a case from, was it 1953? And in the year 1953, the idea of environmental laws was still actually fairly new. Today, we have massive regulatory schemes which deal with pollution. But before legislatures were able to enact these laws, courts started to actually handle pollution cases involving nuisance law. And this is one of the first cases, or the genre of one of the first cases. So Tyler, walk me through here, right? We have two different options, as I said. There's the option of an injunction, or there's the option of damages, right? What would damages look like in this case? How would the court have gone about actually awarding damages?
So damages would have been just paying the property owners, some sort of compensatory damages for the loss of value or the decrease of value of the land, whereas an injunction would have just stopped the oil production or whatever they were finding.
Okay, so between the two of them, right? Which remedy do you think the oil company wanted?
Damages.
Why do you think they want damages?
Because they want to keep doing business and
right.
Just pay out.
And then which the neighborhood? What do you think people in the neighborhood wanted?
They want the injunction.
And why? Obviously. Okay, so but here becomes the problem, right? Let's just assume, and I think Tyler said it well, that the scope of the damages would be how much is their property value being diminished, right? And that's a number we can quantify. Say if the house costs $10,000, maybe now it costs only $2,000, right? You pay a compensation of $8,000 and they're made whole. The fact that their lives are miserable, maybe it had a little bit of money for pain and suffering, but you can more or less compensate to make these people whole. But an injunction to stop the pollution, that would require one of two things. They could either find a way to run an oil refinery without polluting, which is not very likely, or they can shut down the factory. And Eric, what's then the cost of shutting down the factory?
The cost of shutting it down?
Yeah, making them say shut down the factory. You can't do it.
Well, future business, loss of future business, for example.
What else?
And then you have the actual cost of hiring all the people to, I guess at some point.
Hiring or firing?
Well, there's firing involved, and then there's also hiring involved because you can't just shut down a factory. There's a lot of cleanup involved. There's a lot of, shutdowns even now in refineries take months to do just to shut down a certain unit by itself. So
right. So there are significant costs involved with an injunction here because it's granted that this refinery is so close to a residential area that there's absolutely no way that they can actually stop polluting and keep their business up. So more likely than not, they have to shut their business down. Okay, and I think as Eric said correctly, a lot of people are going to get fired. There's going to be significant costs for cleaning up, and whatever economic benefit this refinery gave to the neighborhood to this, this region of North Carolina is gone, right? So for sure, the oil refinery would much rather pay damages, right? So Josh, does the court here seem troubled by the cost to the business of having to actually have this injunction and shutting down?
I think so, yes.
And what do they say to reflect that? I mean, you said yes, but I mean, does the court actually try and consider the cost to the oil refinery in making this sort of decision?
I don't recall exactly.
No, he didn't. What was basically the only factor the court looked at when deciding this case?
The interest in the use and enjoyment of their land.
Yeah. Basically, the only factor they looked at was the injury to the neighbors. Was there any discussion whatsoever about how much it'll cost the refinery to shut down, the number of jobs that'll be lost, that sort of thing? Okay. So here, in one of the earlier cases, this is indeed a common law approach. If there's a nuisance, you issue an injunction to stop it. Even if damages would make whole the property owners nearby, under the common law, that was not the remedy. And I think it says in the very end, it says, there's a private nuisance which entitles a plaintiff to injunctive relief. Period. That's it. I mean, we don't actually know what happened afterwards. I mean, it's very likely that either, well, one of two things happened. But what do you think, Jack? What do you think happened after this case? Do you think the oil company went out of business? What do you think actually happened here?
I mean, probably not.
Yeah, what do you think they did? If you had to guess, they got this injunction in hand. What do you think they did just to fix the situation?
Probably paying some people off.
Exactly. Who did they pay off?
Just the people around.
And you think they paid them for the property value, what their houses were diminished by? What do you think they gave them?
Probably not that much.
Not that much?
I mean, probably a lot more.
A lot more. Bingo, 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 winner. So practically speaking, when the court issues an injunction, right, that doesn't actually mean the factory is going to shut down. It means you're going to take a lot of money. Like, let's just say the cost of shutting down the factory is $50 million, right? Let's go on, Jackson. Easy example. The cost of shutting down the factory was $50 million, right? How much would they be willing to pay off the community to shut up and go away?
They said that they might buy the property from them.
No, the amount of loss that the factory would suffer would be $50 million. Let's just make it an easy number, right? How much should the factory be willing to pay to make the neighbors shut up and go away? I want a number.
If it's worth
If the company will lose $50 million if they shut down,
Oh.
how much should they be willing to pay to make the neighbors shut up and go away? How much? There's a really easy question. What's the maximum amount of money they're willing to pay to make the neighbors shut up and go away? Why 15? I said 50 was.
I thought you said 15.
Okay.
I'm sorry. You're getting mixed up in 15 and 15.
Oh, I'll blame the microphone. Okay, good. So if the factory could lose $50 million, and just make it easy, round number, right? They're willing to pay up to $50 million to basically settle the case and make the neighbors live with this pollution. So an injunction isn't usually the end of the story, right? An injunction just starts bargaining, but it puts the property owners in a very good bargaining position. Because before the injunction, they were bargaining, all they can get was the value of their house. But after the injunction, they can get a lot more. Everyone see that? All right, so any question in the North Carolina case? Pretty straightforward. They didn't care about damages, only for injunction. So I want to discuss, for example, a case. There's actually a real case in Miami. Anybody know about the Fontainebleau Hotel in Miami? You've stayed there, yes. Anybody know the Eden Rock Hotel? It's right next door. So you have two hotels in South Beach, Florida, right by the beach. You have the, I'm so short. You have the sunny Fontainebleau, and you have the you have the sunny Fontainebleau, and you have the Eden Rock Hotel. And these hotels are right next to each other. And the facts of the case are like this. Originally, both hotels were about the same size. Here, one's much taller than the other. But originally, both hotels were about the same size. The Fontainebleau wants to add an addition and make it much taller, okay? But by making the Fontainebleau taller, it will cast a shadow over the Eden Rock, okay? This is a nuisance, right? Blocking of sunlight is a nuisance, and I'm sure you studied this last year in tort, so whenever you study this. So when the Fontainebleau announced that they want to build it, of course, the Eden Rock sued them for a nuisance and sought an injunction, right? But as we've seen, right, an injunction can be seriously economically damaging. And let's try and work through an example. So Brandon, right? Let's just use really easy examples, really easy numbers. Let's say by building the addition on top of the Fontainebleau to make it nice and tall, right? Fontainebleau would gain $100 million in profit. Just easy numbers, right? $100 million in profit. And let's say by imposing the shadow, Eden Rock will lose, say, $10 million in profit. Again, Fontainebleau will gain $100 million. Eden Rock will lose 10 because of, there's no shade and people can't tan, whatever else, right? How should this case be worked out? Should an injunction be issued?
I think they should be able to pay damages for the loss of $10 million.
Well, how much should Fontainebleau be willing to pay? You said 10. Why 10?
That's how much they would lose, maybe in 1 year. Up to
Just
probably pay up to $100 million.
okay, and that's exactly right. If we have them negotiating, right? Forget about courts for a second. If they're there to negotiate, Fontainebleau should be willing to pay up to $100 million for the price of casting a shadow on the Eden Rock. Because even if they say they pay $99 million, right, to the other party, they'll still be $1 million better off than if there's an injunction. In other words, if there's an injunction, they maintain the status quo. But if they're able to negotiate and reach this arrangement, they'll still be better off. So economically speaking, the injunction is usually the worst possible scenario, right? It's the stupidest approach because no one is improved. By allowing damages or this sort of negotiation, right, you actually allow both parties to be better off, right? Why? Fontainebleau gets another $1 million, and Eden Rock gets $99 million, right? They're both better off, even though there's a nuisance. So the mere fact that a nuisance is present should not automatically compel you to go to an injunction. Okay? This type of bargaining that I just described is something called the Coase theorem, which has anyone's ever studied this before? The Coase theorem. And it was created by an economist named Ronald Coase, who taught at the University of Chicago. He died at the age of 101 about 2 years ago. He was a brilliant economist. And he basically explained this theory that when you have this sort of negotiation without a lot of transaction costs, right, parties will naturally reach the ideal price for negotiating over these nuisances, right? When parties actually can negotiate without a transaction costs, without things bothering them, they can reach these sorts of efficient agreements. Coase's insight is this: we should not only be thinking about the harm to the Eden Rock, we should also be thinking about the harm to the Fontainebleau. These are reciprocal costs. Rather than only viewing how this will create a shadow over the Eden Rock, we should also view how this can benefit both hotels. By imposing an injunction, both are worse off. By allowing damages, both become better off because an action can be better than they were before the status quo. Okay? And this is nothing too complicated. It's a fairly common sense insight, but it goes a long way of deciding how the first case, the North Carolina case, decided it versus, say, the Boomer case, the cement case. And I think this will give you a little bit more of an insight into how the courts approached it. Any questions on that? Yes, sir.
So that's actually an argument for injunctions, right? Because once you do the injunction, then they're going to be.
No. The opposite. It's actually an argument against the injunction because once you have the injunction, there's unequal bargaining power. And let me ask this question to you because you posed it, right? If there's no injunction in place, right? And let's go back to the example I used before. The Found Blue will gain $100 million. The Eden Rock would lose $10 million, right? Ryan, let's say there's no injunction in place. How much do you think the Found Blue would pay Eden Rock?
Up to 100.
Up to, no, but what do you think the first offer would be?
What do I think? The fair one, or what do I think their first?
What do you think the first offer would be?
Probably the $10 million.
$10 million. And let's say Eden Rock counters with, say, $100 million. And they'll probably negotiate back and forth and want somewhere in the middle, right? Now what happens if there's an injunction in place? And basically Found Blue has no choice but to deal with Eden Rock. What do you think the number will be? $99 million, right? The injunction forces the party causing the nuisance to overpay to settle the deal. They'll go to $99 million. But in the absence of the injunction, it would probably be somewhere closer to 10. And there's a lot of deadweight loss, right? Found Blue is paying way too much money to build this extension, and their own hotels getting worse off. So in the absence of an injunction, they get a much fairer bargain. That makes sense?
So it's just an argument for absence of the judicial system.
Right. So yeah. So I'm waiting for someone to ask me to define the Coase theorem, so I'll do it now. What's happened every year? So it's basically defined in the absence of transaction costs, and by transaction costs, I mean things like litigation, right? Because litigation is expensive. This is how all of your student loans will get paid. You're paying off your fees, right? So in the absence of transaction costs, parties will reach an optimal, allocation of costs or something. When you don't have these sort of transaction fees, parties negotiate and receive optimal value, so everyone benefits. Yes, ma'am. Well, see, in this case, right, the court didn't award the injunction, they awarded damages. And we know this because there's a really tall building there, which Aaron stayed at. In the jurisdiction of Florida, they took the boomer approach, where damages will be better. But had this been in North Carolina in the 1950s, where an injunction was the backstop, an injunction was coming, they could not have engaged in this negotiation. So this insight teaches us that the damages approach is perhaps more optimal than the injunction approach from an economic perspective. Everyone benefits.
Yeah, but why would I, if I was being damaged hard, if I was the Blue Rock Hotel and I knew that my damages were $2 million. I mean, why would I would want way more than $10 million.
Yeah, say maybe 20.
I wouldn't want to cover just my costs.
Yeah, say 20, 25, 30, right? After a certain point, realistically speaking, the Found Blue will go up and say it's not worth it, right? But in any sort of negotiation, you kind of meet somewhere in the middle, right? Even if you're greedy, you'll meet somewhere in the middle because you want to benefit off. Because think about it. As that small hotel stands now, and actually if you look closely, take a picture, see the shadow? Right, everyone see that? What's that? Exactly, right? So realistically speaking, right, you want to make profit. And if you realize that having some shade will inconvenience your members, so long as you're being compensated enough, you'll live with it, right? Maybe the hotel will say, I don't want anything because my neighbors are, my guests are so important, they're very pale, they need to tan, right, from New Jersey. So if this happens, then you won't negotiate at all. But generally speaking, businesses deal with this sort of thing, okay? Let me give you another example. This one's from Dallas. Does anyone know this building in Dallas I'm talking about? Anyone know it? Raise your hand, yeah.
Isn't it right by Park? Is it the apartment building?
More.
It looks like that one.
Okay, so,
It's new.
oh yeah, it's sparkly new, right? So this is a building in Dallas, which is right near, one of the museums. I can't remember which museum. And no, it's a museum with a garden near it. Anyway, so this building was constructed right across the street from a museum that had a garden, right? Unfortunately, when they were building it, they didn't realize that when the sun hits the building, it creates a death ray. It creates a basically focused ray of light which burns a hole in the garden across the street. That is a nuisance, okay? Basically, it's, you know, you ever put like a magnifying glass on a piece of paper, it'll light on fire? Yeah, basically like that. So when the sun hits it at a certain angle, whatever the time of day it is, basically it fries the garden across the street at the museum. Okay, so how do I resolve this one, Will? What's the way we resolve this case?
It's already done.
Well, let me ask you this question. So the owners of the museum or the board of the museum, right? What do you think they argue for? What do you think they want?
Injunction to tint the windows for home shine.
Okay, so that's a good answer. People always suggest this. All right, so couldn't they just recoat the windows? And I've actually done some research on this, and this is actually a true story. So I was Googling this, and I found some message boards where all these people were saying, oh no, it's impossible. There's no way that you could recoat the window. You have to basically take the entire building apart, right? The person who put those comments up was actually the owner of the building trolling. He was actually putting up, it was like on the Dallas Morning News website or something. I mean, I was researching this for a bit. And apparently the owner of the building was like putting pseudonymic comments under a fake name, saying that's impossible to fix. So I don't know, maybe it is possible, maybe it's not. But let's just assume for argument's sake that, they would have to basically demolish the entire outside of the building. I mean, and there are people living there, right? You can't like have a high-rise apartment with like with a hole in your wall for a couple months. Like that doesn't work very well. You'd have to evacuate the building, right? So it's another solution. Ah, no. But the garden was there first. Are you making the museum get rid of their garden?
We could basically live it just like a big block case.
What else could you do to the garden?
Put some kind of cover on it, or shade on the one side where.
Ah, but they want fresh sunlight. They want to look at the sky. What do you think, Spencer? How would you resolve this one?
I don't know.
This is an actual property dispute in Dallas. I mean, you guys are going to be lawyers fairly soon. This is the kind of stuff that actually happens. This is not some sort of fictional question. Huh? Want to take a stab?
No, Professor, I don't want to answer. I just want to ask a question.
Go ahead. That's okay.
Because I don't understand it very well. Because this cost theorem, I think it may be an economic theory.
It is.
So we use the economic theory into our negotiation of the damages. But under the tort law, we use the legal theory. The damages include the temporary damages and the permanent damages. So damages in the future. I think in this case, the $10 million maybe I think it's not permanent.
I said, for argument's sake, pretend it is. Pretend.
Pretend, yeah. But so I don't know what's the relationship with this theory and the legal theory of the permanent.
So there's an entire, and I'll pause. I'll come back to the death ray in a second, right? But there's an entire theory called law and economics, and the idea is that various principles of economics should influence how courts decide cases. And Judge Posner, which I'm sure you studied, is the most, or at least was the most prominent advocate of this theory. And there are many cases in contracts and tort and otherwise that incorporate some certain economic principles, right? So the numbers I made up, $10 million, those are fake numbers, right? A better example would be, say they lose $1 million a year for the next 20 years, right? Could they make a payment of $1 million every year to keep compensating for the loss? Would that be better?
Okay.
Yeah, I made that number up to make it really easy for these guys. I didn't want to, don't overcomplicate the hypothetical. That make sense? But thank you. No, you're exactly right. There are permanent damages and there are temporary damages. Like, so in this case, Jeffrey, what do you think the temporary damages would be?
Temporary damage?
Yeah, from this death ray burning the garden up.
Basically, every year they have to compensate the garden.
And what would be the measure of those costs?
The cost to replace the grass?
Yeah, exactly right. Basically replace the grass. Okay. But what would a permanent damage be?
Just be a one-time settlement, whatever they figure it out to be.
Basically, yeah, and this is Nolly's point, the loss of having the garden, because the garden is no longer sustainable. So the temporary damage would be every year replacing the sod or the grass or the plants, and the permanent damages would be the actual not having a rooftop garden. So I want to show you a little bit, you guys obviously aren't creative enough, right? Anyone see this? So some guy actually proposed a solution of building this massive arch across the street from the garden. And there are these like kind of like umbrellas, if you will, that open up and block the sun rays from hitting the garden. Everyone see this? So, yeah, I'll stand up. So here, there are these thin little, think of an umbrella, and then at certain times of day, they just go poof, open up. And by doing so, it creates effectively a wall which blocks the sun, just like Mr. Burns stuff, right? To prevent the thing from burning up. Here's a better picture. Yeah, anyway, so, but the question here becomes, let's say the cost of replacing, and let's pretend this sunblock thing doesn't actually work, right? Let's go to Nolly. Oh, perfect. You're up next, Nolly. Let's go to your question, right? Let's say the cost of replacing the grass, $100,000 a year, right? Just really, really easy number, $100,000 a year. Let's say the cost of, replacing every window in the building so it's tinted is $100 million. And that includes the cost of, providing temporary residence for the people living there and everything else. So again, to replace the grass, $100,000. To change the building, $100 million. What do we do here?
I will choose the lower cost.
You're the judge, right? Why do you tell the people in the garden, too bad, you can't have a garden anymore? I mean, sucks to have brown grass, but deal with it. Well, I'm asking, what do you think? You said you choose the lower cost, $100,000 to replace the grass. Why?
Because it's lower.
Yeah, right. It's lower. Well, so I think though what you're internalizing is actually the cost theorem, right? You're trying to achieve an efficient allocation of resources, right? There's a serious loss to society as a whole when $100 million needs to be spent, when you can actually fix the problem more or less for $100,000, right? This is not an ironclad rule, and I think, again, this illustrates the difference between the injunction versus the damages for the remedy. Any questions on the Dallas case? Actually, I was driving through Dallas the other day, and I was like, oh, there's the Death Ray building. Yeah.
So that wall is in place, or
no? That's fictional, right? I was doing research on what could be done short of actually demolishing the building, and I looked up the tinting, and the owner was basically trolling, and then some architect actually designed this. Here's the other picture. It looks pretty ridiculous. You imagine like these umbrella things popping up. I'm sure the museum exactly wants that, but it'll probably be cheaper than taking down the entire building, because the exterior of the building is part of its foundational support. You can't just remove the exterior of a building. It doesn't work like that. If anyone's watching the Marriott Marquis getting built a couple blocks away, they're basically putting the glass up with the support of the building. This is part of the building. You can't just take stuff down. Especially, I think this building is basically entirely glass on the outside.
In the event of that wall, who would pay for it?
You tell me.
The apartment?
I'm guessing the developer would have to pay for it, I suppose, but the museum, and these are a bunch of Dallas, the elite of Dallas, are probably not interested in this. They want to keep their garden as it is. So let's do another case a little close to home. The Houston case, was it Estancias, right? I think this is the only case from Houston the entire semester in your book. Did you guys? All right, Alejandro, you're up. What happened in the Estancias case, please?
Those homeowners who live near an apartment complex, they complained that the complex's air conditioning unit was bothering them, creating a lot of noise.
Not just it was bothering them. How loud was this air conditioning unit?
So they basically couldn't function unless everything was airtight in their home. Had trouble sleeping, couldn't have people over for
Yeah,
entertaining. And stuff.
exactly, right? So here's the situation, right? You had an old couple living in a house. They'd been there for quite a number of years. A new high-rise apartment complex goes up right near their property. I think they said the air conditioning was 5 feet from the property line and about 55 feet from their home. So everyone's seen these massive air conditioning units, right? They are loud. They sound like jet engines. They're extremely loud. Okay. Alejandro, how much would it have cost to replace this massive air conditioning unit with individual units in each apartment?
I believe it was 150K to 200K.
To actually get rid of everything, right?
Yeah, to change the system.
Good. So the actual cost of taking out this massive air conditioning unit and putting in individual boxes in each window would be $150,000, $200,000, right? So before we get too far, can anyone think of a solution short of installing individual units, how they could have actually fixed this case much easier? I want to try to be creative.
It's common sense and not put a big air conditioning unit next to a person's house.
Yeah, where should they put it?
They could have put it on the
Somewhere else. My God. Okay. This is why this case, and Jeffrey, you're exactly right, but this is why this case might be a little bit jarring. They presented as two alternatives. Keep this massive jet engine right near the property line of the neighbors, or rip apart the entire building, put an HVAC and do everything else. Why can't they? Move the unit onto the roof, or move the unit somewhere else so it's not next to it, right? As it turns out, I don't know if anyone, there was a note after the case, I don't know if anyone got that far, but as it turns out, they just moved the damn thing. They moved the unit. Okay. So, Greg, why do you think they didn't just move the unit outright? Why do you think they took this to court? Why do you think they didn't just move it outright? Why didn't they actually challenge the court? What do you think their calculus was? What do you think they figured by challenging this in court?
Well, they only lost like $10,000, so maybe it's.
What do you think the apartment building thought they'd be on the hook for?
They're on the hook for?
What do you, if you were their lawyer, right? They walked into your office and said, okay, what's our exposure? How much are we going to lose here? What would you have told them? What do you think? What do you think their lawyer told them?
$10,000.
Where do you get 10,000 from?
Because that's what they came up with for 9,000 in a wife and 1,000.
Okay, good. Their lawyer probably advised them that the extent of the remedy would be the diminution in value, right? That this old couple, they lose about $10,000 of their property value. And they probably made a calculation that $10,000 was a lot less than relocating their unit, right? And they were hoping that, Nolly was the judge, right? They were hoping that the judge would say, wow, $200,000 to replace the unit or $10,000 to pay off the old couple, pay them off. That's probably what they were hoping. I'm guessing that's what their lawyer advised them, right? So Tyler, what in fact did the court do here?
They, I believe they made them move the.
Well, no, they didn't make a move it. What did the court find here? What was the remedy? Be very precise.
Although there was a nuisance, they still had to, I guess, bring up the issue to decide the best way to go about the damages.
What was the remedy that the court awarded here?
Was it
It's got to be one of two. What was the remedy that was awarded?
the injunction
They gave an injunction, right? What does the injunction mean?
to stop the whole process?
What's the injunction for? Be very precise.
to not to go about the whole transfer the air conditioning.
No. What was the injunction going to do? What was the neighbor's problem?
The noise.
Yes, what would the injunction do?
Move. They wanted to move.
No. What
Stop
does he?
it.
No. The court doesn't tell you how to fix it. What does the injunction say? If you're thinking way too hard. What do the neighbors want?
They want the sound to go away.
Yes, what did the injunction say?
Stop sound.
Yes, bingo. All the injunction says is you need to get rid of the sound by the neighbors. That's all it says. It doesn't say go put it on the roof or go do this or go do that or go, what. It just says stop the noise. The same way the other one says stop polluting. They don't care how you do it. They care that you do it. Okay. Once the injunction was issued, though, right? Did the building, rip up all the HVAC? No, as I mentioned a second ago, they just moved the damn box. But let's just assume for a second, Will, that they couldn't move the air conditioning unit, right? Let's just make an example. It's too heavy to put on the roof, and there's nowhere else in the block where you could put it, right? Maybe it needs to be close to an electrical hookup. I don't know. Make up a reason. But let's say that they could not move it, right? Should that have affected the court's analysis? Let's say the only way of giving the situation is to spend $200,000 by installing a unit in each apartment.
I mean, it's going by the common law rule, and no, it wouldn't make any difference. It's just spread it out.
Okay, what about the modern rule, though?
The modern will be with the boomer rule,
Mhm.
the equitable consideration.
So what does it say to the old couple living there? Are they just screwed? They have to get 10 grand and they can't live in their own house?
Would it be like a temporary damages kind of scheme, and they pay each year for their condition value, or
Couldn't the apartment building just buy out and just buy the house of the old people and say move out?
probably could.
Is that fair?
I mean, not to the old couple, that was where they lived for so long, there's multiple reasons why they stay in one location.
What about earplugs? That's a really cheap remedy. Earplugs. Bose, noise canceling headphones, like really good ones too. I'm serious.
I mean, is it
Spending $200,000, spending a couple bucks in earplugs.
I mean, I just don't see it as an equitable solution to force the older couple that to change their lifestyle because they don't want to switch around their conditioning units.
Okay, and you see here, this is basically the trade-off, right? There's usually a very cheap solution to these sorts of nuisance questions. Earplugs, right? Buy them out for 10 grand, let them move, and don't worry about it. But that, doesn't take into consideration the value of the needs of the people who are being bothered. So the common law approach was just, yep, issue an injunction, be done with it. So let's go back to what happened with Ashby, right? Ashby, they said, okay, we'll let you build this high-rise tower, but we'll give you money. We'll simply make you a one-time permanent damage for the diminution in value. So if your house in Rice Village was worth $200,000, now it's worth $150,000. You get a one-time payment of $50,000. Enjoy the shade. I mean, that's basically what they're saying. I don't think that's correct as a matter of Texas law. And I actually, the Chronicle interviewed about this about a year ago. I'm pretty sure under Texas law, the remedy is, if it's in fact a nuisance, it's an injunction. I think the court was trying to have it both ways. It was actually a jury trial, so I think the jury was trying to have it both ways. The court kind of whatever, but they were trying to have it both ways. Allow the bill to go up and compensate the neighbors. I'm pretty sure it's one or the other. And actually, I don't think there's even a nuisance under Texas law, but that'll be resolved by a higher court shortly. Very interesting development. Very interesting stuff. Okay. So any questions on the air conditioning case? Yes, yes, sir.
Didn't they take in the balancing equities in this one? They just said that they didn't argue it.
Well, how would the balancing equities work here? I mean, you have a $10,000 loss in a court and a $200,000 cost for the business. I mean, the equities go one way here, no?
I agree. They seem to talk about like principles of justice in the public, but they're saying that they never argued in the case that they did bring it up, so they court business. It's on the bottom of 787.
Yeah, I mean so they make references, right, to fairness principles, but the fact that issuing an injunction means they're not, right? The injunction, which is a common law approach, doesn't really consider the cost, even if they say they are, it doesn't really consider the cost to the apartment building. Like, I know they say they are, but it's effectively going with the common law approach.
I mean, they brought up like not allowing the apartment or the AC would actually be something to the public. Just, but then they say Houston doesn't have short living spaces.
Yeah, I mean, and also, do you really want to have a building in Houston where there's no AC for the summer? In the time to get this replaced? I mean, that would be unbearable for 300 people living there. It would be a significant cost to not only the owner of the apartment building, but also the residents there, because then they have no AC for the year. Because this stuff takes a long time to fix. Has anyone ever had an AC go out in the building for a while in Houston? Bad, right? Yeah. I've been living here now a couple of years, and it would be unbearable. I would probably move. So there's significant costs here by issuing this sort of injunction that it didn't obviously move the court. But you're right. They mention this stuff, but it's almost like, you know.
Just like they brought it up and then they really
Exactly right. Yeah, it's like, never mind. Just kidding. But again, this sort of injunction is why I think under Texas law would probably be the rule, which is why the Ashby decision still seems anomalous to me. But, you know, what do I know? Any questions in the air conditioner case? All right, Omar, let's do Boomer. What were the facts here, please?
The defendant operates a large cement plant. With a plaintiff brought an action for injunction to stop the operation of the cement plant and damages alleged from dirt, smoke, and violations.
Yeah. So if you've ever been near a cement plant, there's a lot of vibration, dirt, you know, stuff flying around the air, right? It's a very, very, you know, a dangerous place. It's very noisy, very dirty, right? So you had a number of homes that were in a vicinity of this cement factory. And what year is this case? 1970. So again, this was still at the outset of environmental laws. The Federal Environmental Protection Agency was created by Nixon in maybe 71 or 72, might be off by a year, but basically it hadn't even done anything yet. So there was very little sorts of environmental laws. And the neighbors in this area, again, brought suit claiming a nuisance. And I think here the court makes a number of comments about public policy, right? Jimena, what does the court say about the courts versus the legislature resolving these sorts of environmental issues? What's his thrust?
Well, first is to say they don't have the scientific knowledge to be able to make decisions on such large policy issues that are left legislation. Legislation are scientific.
Right. What can the legislature do the courts can't?
Create regulations or policies.
But what does the legislature have that the courts lack? Well, courts have power, unfortunately. No, but what is it that what's unique to legislatures that allow them to do these sorts of things that courts cannot?
Like the courts when they're handling situations between private parties, and then if these being now these are large, massive things. So legislation.
Yeah, exactly. Okay. So how do courts resolve issues on a case-by-case basis, right? This is common law 101. They can only resolve cases before them based on the facts before them. When you lay down a common law rule, it's usually not very specific. It's some sort of general rule that hopefully another court can apply in the future. When legislatures rule, they make broad statements. They can say something like, no cement plants within 100 feet of residential areas, period, right? That's easy to apply. Could a court ever make a holding, no cement plants within 100 feet of residential area? Of course not. They'll say, well, in this case, the plant was too close and there was a nuisance and we will issue an injunction in this case, yada, 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 right? So I think the court here has a attitude of basically saying, look, private litigation from a single plant should not be used to make broad environmental policy, right? We should not be making this broad policy. This should be something that the legislature should do, not private litigation. Okay. So, Michelle, so since the court isn't interested in making these broad sort of environmental statements, how does it go about resolving this issue then?
Comparing economic consequences, it's so great that one permanent payment of damages is better, and it will essentially terminate the private litigation. So they just pay one time for.
Why don't they issue an injunction? Wouldn't the injunction be like in the North Carolina case, stop the cement plant, shut it down, or find some way to put in a filter or a dampener or something?
It would cost a lot more.
Good. Okay. So what are the costs here? Thank you. Oh, you're good. Move on. And Natasha, what are the costs here? What would the cost be? Cosby, right? What would the cost be to shut down the cement plant or the cement plant?
So,
What losses would the cement plant suffer if the plant were to be shut down? Give us numbers. Peter, you have it? More than that. Yeah, a lot more than that. Stephen? No. Anybody? 45 million, thank you. Come back to Natasha in a second. $45 million. If an injunction were to issue, right, there'll be a loss of $45 million of investments, right? Also, this plant employs 300 people. They'd be out of jobs. The court here is balancing the equities, right? Ryan, you asked before balancing the equities. This is actually balancing the equities here. So the measure of damages, right, is $185,000, right? Whatever the loss of property value. The cost of shutting down the factory trumps that by several orders of magnitude. $45 million, employing 300 people, basically put a factory out of business. Okay. So Natasha, why can't the court just say find a way to operate your cement plant without creating all this pollution? Why don't they just say try and fix it, then we'll come back to this later? Could it even be done? Okay, and the court's actually basically being pretty realistic, right? This isn't a case where they could just move the air conditioner to the roof. The court's saying you're running a freaking cement plant. There's no way that you can operate this business lawfully. I'm sorry, without making a nuisance. So, because we will be just silly by giving you an injunction, put all these people out of work and cause millions of dollars in damages. And $45 million in the 1970s, it's a lot of money. So what the court just says is they got rid of the injunction, they reversed it, and they issued damages, right? And the court's saying, look, we're a court. We should not be in the business of resolving these air pollution problems. And they say this explicitly. The total damage to the plaintiff is small compared to the value of the defendant's operation, right? This is Nolly's question before, right? The value is teeny to the plaintiffs, as rough it is to their lifestyles, right? But the cost to the defendants is great. So this is the true balance of the equities.
So balancing the equities, is that a pure numbers thing? Like don't take anything else into account? Just what is the damage to one, what is the damage to the other?
Well, I mean, you can consider how unfair it is for those poor children getting scared by the cement blaster. Does that seem to trouble the courts? Right. So Nolly's question, are courts incorporating economic theories? Well, yeah. This is a pure numbers, dollar and cents factor. And the court does not seem to be afraid that there are these poor little children cowering in fear of the cement machine. They're saying that people will lose their jobs, the community will shut down, and there'll be a loss. And that seems to be driving almost entirely the court's analysis here. Okay. Questions on this case? As it turned out, the damages awarded were far more than $185 or $710,000. So perhaps the lower courts being a little more generous for the loss of, aesthetic quality of a lifestyle. But still, even $700,000 pales against $45 million. in modern times today, these sorts of suits are almost never brought as nuisance. Every state has various environmental agencies that protect against pollution. And rather than having private litigation where people in the neighborhood have to sue, the state agency steps in and fines the polluter. And this is significant for a number of reasons, not least of which is that you don't have to hire a lawyer if you live next to a polluting entity. You go call some phone number, you ask them to make an inspection, and they do an inspection, and then they send a letter, and after the letter comes a lawsuit, right, if they don't fix it in time. Remember, we did a case a couple weeks ago from Connecticut where there was a wetland that was filled with cement, right? These sorts of things are handled by environmental agencies. And these agencies can pass various rules saying, you know, you can't have a cement plant within X number of feet of a residential area. And if you do, you need to install certain technologies. And these agencies are far better equipped than courts to deal with it. Okay. This is another reason why the Ashby lawsuit, I think, is potentially a dangerous trend, because it's moving back to the olden days where courts are handling these sorts of issues that are really best left to zoning boards. But of course, Houston, we have no official zoning board, so effectively litigants are using the courts as a substitute for zoning. I actually call this backdoor zoning. If you want to read an article about this as well. But this is an interesting development where you don't have a zoning board, litigants, private landowners in the Rice Village area, people tend to be quite wealthy, can go hire lawyers and sue to stop them. You see stopashbyhighrise.org. There's a website that all these protests. This was actually crazy. Anybody remember this? A number of years ago, they want to illustrate how bad the traffic would be. So they all just drove their cars, I think, onto Greenbrier, and they just parked in the middle of the street. It was like a park-in to illustrate how bad traffic would be. Again, people who during rush hour have nothing better to do with their lives and park their cars in the streets tend to be well off enough to hire lawyers, I suppose. And there are a number of pretty wealthy people there who actually paid for lawyers. One of them was a lawyer themselves. Most people are trying to get home to their families during rush hour, but I guess you know, this works okay. So the Boomer case and the North Carolina case, I think, represent, you know, different poles of the spectrum, right? The North Carolina case wasn't at all concerned with the equities. He said, if there's a nuisance, issue an injunction, stop it. The Dallas case, the Houston case, talked about the equities, but eventually it said, issue an injunction, stop it. The Boomer case said, listen, we're not getting into the business of trying to destroy the cement plant. Let's issue damages, make people whole, and let's let things go on, and maybe an environmental agency can take stock. So the Boomer case is a lot more the modern approach, and I think you'll see this. Obviously, the Ashby court was emulating it. Yeah, the annoying part of the Ashby decision, though, was it was a jury trial, and so there's no written opinion. There's basically just a jury verdict form where the jury voted on questions, yes or no. So basically, hopefully this year, it's been going on for, hopefully we'll have an appeal, and there may be an appellate decision I can teach for when I teach this next time. I was actually looking at my notes from this, and I said, construction should start in 2014. I had to scratch that on my lecture notes because that didn't happen yet. All right, any questions on Boomer?
So now state agencies, do they collect the fines and pay?
I'm sorry, state agencies, I think the last part.
Do the state agencies or federal agencies collect fines and then pay the residents?
Oh, no. No. Most state agencies that collect the fines put in what's called a judgment fund. The private, well, let me put it this way. Occasionally, if there's actual damages to the neighbors, they may get some sort of money, but generally speaking, the neighbors don't get anything. Generally not. Yeah.
I mean, isn't it at some point I'll use Ball Line as an example. I mean, it's just absurd at this point because the cost of doing business is just paying the fines.
Mm-hmm.
Nothing gets cleaned up, nothing changes. The river, from when I was growing up, has more than tripled in the last, since the 90s. And plus, there's the presence of mercury, cadmium, and a few other things that weren't in there in the 90s. And all they do is just pay the fines to TCEQ, and then they're done. I mean,
the Texas something quality, what's the stand for?
Texas Commission on Environmental Quality, is about worthless. But in addition to being liars, but
You're not speaking from experience, are you?
Well, no, about 3 years ago, the Houston Chronicle ran an article on how they had been fudging numbers about Houston's water qualities for years.
Mhm.
So, but anyway, I don't see how that actually fixes anything. The big companies just calculate into the cost of doing business.
Right. So I mean, this is one of the downsides to the boomer approach, because you can basically figure out what's the cost for me polluting, right? How much can I afford to pay in order to engage in a nuisance? Whereas under the old approach, it's an injunction, so you're damned. But of course, the downside to that is the injunctions are very broad, and they may create other losses to the business. In fact, they go under, people work for them. So I'm not endorsing one side or the other, but I hope you can appreciate that there are costs and benefits to both the injunction approach as well as the damages approach. Yes, sir.
So now citizens who are damaged by this and that not have recourse.
They may be able to get some money from the state, and I don't know the details how that works. But generally speaking, the money of the fine goes to the state, and I suppose the neighbors can petition from the government to get some of it back, right? But the state's involved in the heavy lifting.
I mean, the people who are actually damaged get them.
I didn't say that. I think they have to recover from the state. They actually have to file a claim or something with the state. Yeah, you don't seem happy by that. I don't know. Apparently they're a bunch of liars. Any other questions on Boomer? No? All right, let's move on to the last case, which I guess you studied already, the Del Webb case. We have two. Peter, what happened in Del Webb?
So Spur Industries operates down feedlots.
By the way, what's a cattle feedlot? I had to Google this when I first started teaching. I didn't know what that was.
Where they all feed.
Yeah, anyone ever work on a feedlot? Want to tell us about it?
Wait on one.
Oh, where is it?
At the top of Texas Panhandle.
Oh, cool. Okay, tell us about it.
You have a bunch of pins that's just dirt pins that have water tanks on either side, and one side has a long continuous feed bunk or cement trough, and then you run by with a truck, put feed in that, and the cattle just eat there instead of eating grass. So you can feed them grains. And
How many head of cattle do you have on your farm?
our feedlot holds 1,000 at a time.
1,000.
Really small.
Okay, that's fine. Anyone else have experience? Yeah. How big was it?
The feedlot I worked at, I don't know.
And how bad do they smell?
Well, it depends on what you're like. You get used to it. Where like our feedlot, we can't smell, and it depends on what you feed them as well. Our feedlot smells different than the one that's a mile down the road because we feed them different.
Really? What's just pro tip? What's the less smelly stuff to feed them?
The
Worst smelling?
Go for it.
Expired candy.
Really?
Yeah.
That's what you feed it to cows? Expired candy?
Yeah.
Why?
I'm not sure how to.
It's like after Halloween, whatever's left over. I
No,
mean,
it's just expired candy left over from the stores and stuff.
what do you guys feed them?
corn, Milo.
Yeah, corn sounds better. not candy corn, but corn. So here's what happened. Okay, so I'm sorry, Peter. So go on. What was the deal with the feedlots in Maricopa County?
So Webb developed company came in. They wanted to develop out the area. They pretty much advertised nice outdoor living. You can enjoy everything. And with these feedlots so close, when the Webb kept developing out, they came close to these feedlots and wasn't able to. The people weren't able to go outside.
Well, chronologically, right? When they first started building these residential communities nearby, where was the feedlot?
Far away.
Okay, far away. So this is a map in 62. See, the developments are up there, the feedlot's over here, right? But as they started to grow, what happened, Peter?
They started coming closer to the feedlot.
Right, they started coming close to the feedlot. And then contrary to Will's lack of sense of smell, this smelled really bad. Will, give me a sense. 1 million pounds of manure a year. Is that a lot? That's a lot. Yeah. Okay, that smells bad. And under state law, a nuisance was defined to include things that attract flies. Is there a lot of flies attracted to 1 million pounds of manure?
Yes.
Yes, sir.
Guys come out every single week to bait for flies.
For what?
That have, there's these little pellets that flies will eat and die.
Oh.
And they come out and put that around our feedlot once a week.
Oh, so like a pesticide type of thing, right?
Yeah.
Okay. So the problem here was there was in fact a nuisance, right? And no one disputes that having 1 million pounds of manure right next to a residential community is a nuisance. Okay. But the question is, what do we do about it, right? So Stephen, what are the options? How could the court have approached this case? What could have been done? What could have been the options? There are two options. Yeah. What are the? Well, okay. Well, we may have to in a second. What are the two general options that can be done? Okay, so an injunction would mean what?
They stop feeding cows.
Right. In other words, is there any way? Maybe Will can answer this. Is there any way for feedlot not to have smelly cows? Will? Right. So is there the injunction basically mean what, Stephen? Move. Okay. What would the damages be? And under the traditional approach, who would be paying the damages?
The feedlot.
The feedlot, right? The feedlot would be paying the damages. And what would they have to pay to the developers?
Loss in property value.
Yes, right? So this is traditionally the case would boil down like this. An injunction would mean they got to shut down the feedlot and move it somewhere else, right? And that's not free. That comes at a serious cost, right? Well, how much do you think it would take for you to move your feedlot? Okay, a lot of money, right? You have to get all those cows and herd them and I don't know, whatever else, right? The damages were basically saying, we'll pay you to allow us to have our smelly feedlot across the street, okay? So if this were a straight up, boomer type case, it would seem that the feedlot would be out of money either way. The feedlot would either have to pay to relocate or the feedlot would have to pay damages, okay? So Caitlin, oh, I'm sorry, I skipped Evan, I'm sorry. Evan, there you are. Evan, how does the court think about resolving this question?
They tell them that they have to move and they get the developers to help cover the costs of their.
Why are the developers, aren't the developers being burdened by all this, smell? Why are they in the hook?
Because the feedlot had been there since like 1911.
Uh-huh.
They'd been there forever. And
what's the name of this doctrine that you're describing?
Doctrine?
Yeah, what was this thing called? You're describing it. Kaylin? Yes, ma'am. Coming to the nuisance, right? So the court says like this. The feedlot here, yes, they're at fault for having a public nuisance, right? There's no question that their poop and their smell is causing all this difficulty. But the developer is also at fault here. Why, Caitlin?
The cattle feed company was running a lawful operation and been there for a long time.
Right. So here I think is where we see some of an equity kick in. This coming to the nuisance doctrine is basically an equitable creation. If you're responsible for building near the nuisance, right? You were there first, you were making the nuisance, and there's nothing around you in the middle of the desert. And then someone builds across the street from you, they can't claim that they're affected by it. So they have to move, Norma, right? They got to move. Who pays the cost of their move, though? Exactly right. The developer indemnifies the cost of the move. The developer pays the cost of the move. So even though there's an injunction in place, there's an injunction present saying they have to get lost and move their cow somewhere else, the developer, because he came to the nuisance, is now responsible for paying for it. And I think this case illustrates both sides of the equation, right? And you can think back to the Eden Rock and the Fontainebleau. So both parties will be better off here if they move. right? Because the developer will have not smelly, and the feedlot can continue operating. But who pays the cost of that shift? And here the court assigns the cost to the party that caused the problem, right? So even though there's an injunction here, the court saw some sort of economic theory behind it because they're basically forcing the developer to compensate for the loss of the move. Okay. Any questions on Del Webb? Yes, sir.
Do you know if they actually moved? Or
Yes, yeah. It was actually mentioned in a note after the case that for an undisclosed amount, they actually, and that covered the cost for location, loss of profits and expenses, feedlot moved somewhere else. Like, can you imagine how difficult it is to move an entire 30,000 head cattle on somewhere else?
I mean, the cattle, the easy part is the building the new feedlot, do all the dirt work and get it, because you have to have it run off, because not only is that mirror there, but whenever it rains, the rain takes it and has to go somewhere and collect. You do a lot of dirt work before you can start building things to move cattle.
Dirt work, I have no idea what that means, but I'll
just
think
taking some machinery and moving the dirt to where there's slopes that channel the water to where you need it to go.
How big would this feedlot be? That's 30,000 head. Is that a really big lot?
Like ours is probably about the size of 4 city blocks. It's only 1,000 head. So
it's a lot of blocks.
Yeah.
Okay. Any questions? Yes, sir.
There's a difference between coming to the nuisance, because this was way outside of the city limits, as opposed to the city expanding and then eventually getting to it.
Right. So the alternate is people. This coming to nuisance doctrine isn't like a black letter rule. And again, I think I describe it best as an equitable principle, where a cost is assigned and they can basically shift the cost back to the person who created it. But if this was a situation, I don't know, say if you're living in like Katy 30 years ago, right? There's absolutely nothing there. And now basically I-10 is just creeping out to Katy. Now you have basically these high-rise buildings right by Katy Freeway. When it's a slow, gradual development, I don't think you claim the coming to the nuisance doctrine. Whereas it was a sudden, gradual thing where the guy just bought up all this land on the cheap. And the reason why it was cheap was because it was next to a feedlot, right? And then he had the chutzpah to then sue to have it move away. And the court wasn't going to have that.
So how do you think the court would rule differently if it was like a cheap?
Well, I don't think the doctrine would work like that, because if there was a gradual development, they wouldn't be taking advantage of really cheap property prices. I think what was underlying here was that you had some sort of a developer who bought all this land really cheap, and then said, "Oh, once my people actually move in, I'll just sue to get rid of the feedlot." I think that was also circling underneath the hood in this case, but not clear. Questions? Okay, so I think the lesson for today, in terms of the nuisance, and I think what I want you to glean from this is not just whether it's a public or private nuisance, or whether you have a nuisance that can be abated by an injunction, but how is it that courts are going about deciding whether to assign an injunction or the damages, and to what extent is equity and fairness playing into it, or is it pure economic theory? I think the Boomer case is a purely economic theory. I think the Webb case is economic theory with a little bit of equity built into it. The North Carolina case is pure common law, issue an injunction or else. And the Houston air conditioning case is, well, we'll issue the injunction, but we'll at least pretend to talk about the equities. And I think these 4 cases give you a nice smattering of how different courts approach this issue. All right, any other questions? Have a good night, L'Shana Tova, and I'll see you guys on Monday.